1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်248 RATANLAL Applicant vs MAPL Firm by မတ်အောင်ကြီး and 1 Respondents ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစော်မင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil Miscellaneous Appeal before Uttarphe Judge RATANLAL Applicant vs MAPL Firm by မတ်အောင်ကြီး and 1 Respondents Code of Civil Procedure Dismissal order for default of appearance whether the court should proceed under Order 17, Rule 2, Civil Procedure Code. Held the dismissal order of the Additional Chief Judge for default of appearance by the petitioner on the date fixed for filing of affidavit of documents must be deemed to be one made under Rule 2 or 3. Order 17. In a case where the default under Rule 3 is coupled with the default under Rule 2 as well, the court should proceed only under Rule 2. Maungkhanji and 4 versus Matatne and 6, 3 Rangoon 63. Amar Singh versus Chata Buch and others AIR 1957. Rajasthan 367. Matlanyo versus Maemin and others AIR 1937. Rangoon 437. Prativadi Bhayankaram Pichama versus Kamisati Surya Mula and others AIR 1918 Madras 143 FB refer to Achabi for the applicant SAA Pile for the respondents Uttarphe Judge in Civil Regular Suit numbered 102 of 1964 of the City Civil Code Rangoon, the petitioner sued the respondents for recovery of Jet 5,000 due on a promissory note on 1st July 1964. The learned additional chief judge who took up the trial of the suit ordered the parties to file affidavits of documents by 15 July 1964. The parties were not ready with their affidavits on that date and asked for further time, which was extended till 29 July 1964. On the day thus fixed, both the petitioner and his advocate were absent and the suit was on the oral application of the advocate for the respondents dismissed with cause on 31st July 1964. The petitioner applied under Rule 9, Order 9 of the Civil Procedure Code to set aside the order dismissing his suit, but the learned chief judge, who then had ceased of the proceeding as the learned additional chief judge was assigned to duty as well, dismissed the application on the ground that the order dismissing the petitioner's suit being one under Rule 21, Order 11, Civil Procedure Code, could only be appealed against or reviewed on the authority of Maungkhanji and 4 versus Matatne and 6, 1. Hence, this revision application It has been argued on behalf of the petitioner that the learned Chief Judge had misinterpreted the order date the 29th July 1964 passed by the learned Additional Chief Judge as being one under Rule 21, Order 11, Civil Procedure Code, inasmuch as the order to file affidavit of documents was not purported to be made under Rule 11, Order 11, which requires that there should be an application for discovery of documents by one of the parties. His contention, in short, is that the order of the learned Additional Chief Judge in requiring his client to file affidavit of documents must be deemed to be one under inherent powers of the Code as provided by Section 151 of the Civil Procedure Code, and that the provisions of Rule 21, Order 11 will have therefore no application to the order of dismissal in the instant case. Now, Rule 21, Order 11, Civil Procedure Code reads, where any party fails to comply with any order to answer interrogatories or for discovery or inspection of documents, he shall, if a plaintiff, be liable to have his suit dismissed for want of prosecution, and if a defendant, to have his defense, if any, struck out and to be placed in the same position as if he had not defended, and the party interrogating or seeking discovery or inspection may apply to the court for an order to that effect, and an order may be made accordingly. It is clear therefrom that a suit can be dismissed under this rule only on three grounds, namely, 1. The refusal to answer interrogatories under Rule 11, 2. The refusal to make discovery of documents under Rule 12, and 3. The refusal to permit inspection of documents under Rule 18. The same view has been expressed in Amar Singh vs. Tata Bush and others too. Now, Rules 11 and 18 undoubtedly have no application to the present case. Rule 12 also will not apply inasmuch as there is no application by the respondents for discovery of documents when the court order the parties to file affidavits of documents. It must therefore be assumed that the dismissal order of the learned Additional Chief Judge for default of appearance by the petitioner on the date fixed for filing of affidavit of documents must be deemed to be one made under Rule 2 or 3. Order 17. In a case where the default under Rule 3 is coupled with the default under Rule 2 as well, the court should proceed only under Rule 2. I am fortified in this view by the decision in Malanyo vs. Maimi and others 3, in Prativadi, Bhavangaram, Pichama vs. Kamisadi, Sriyamula and others 4. It was held that there is no conflict between Rule 2 and 3, Order 17. They are independent and mutually exclusive. Where the requisites of Rule 2 are satisfied, that Rule and not Rule 3 should be applied, although, in addition to the absence of the party, circumstance exist which would satisfy the requirements of Rule 3, Rule 2, Order 17, these with cases of absent all parties, and Rule 3 with failure to do what was ordered. If the party fails to appear, Rule 2 applies and the court should not assume that he is guilty of default and apply the stringent provisions of Rule 3. Rule 3 applies only to cases where the parties are present and have not satisfied the court as to the existence of any adequate reason for their not having done what they were directed to do. Of course, the court is at liberty to proceed under Rule 3 to decide the suit forthwith when there are sufficient materials on record. In the instant case, it is clear from the order of the learned Additional Chief Judge that the suit was dismissed for default and not on merits of the case, since the dismissal order could only be interpreted as being made under Rule 2, Order 17. The provisions of Rule 9, Order 9 will apply so that the petitioner can ask for restoration. The learned Chief Judge therefore erred in holding that such an application is incompetent, and this order is accordingly set aside with course. I further direct that the application shall be readmitted by its original number and proceed to hear according to law. Advocate fees, Jet 34,